Process, winner of 15 New York and Mid-Atlantic Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights.
The intellectual architect and the soul of the modern rights revolution is William J. Brennan.
Against which the Chief Justice of the United States once said that we merely judge balls and strikes.
Harvard professor Lawrence Tribe on his hero William Brennan and his one-time student John Roberts. The Newark native and iconic liberal Supreme Court justice in marked contrast to the conservative current chief. Up next, the second of two due process programs looking back at Justice Brennan, the judicial philosophy that informed his 34 years on the court, and the opposing approach that now holds sway.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law. And by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by the PSCG Foundation and the Thomas and Agnes Carvel Foundation.
Two new justices have joined the High Court, both Democrats named by the Democratic president. But when they appeared for their confirmation hearings, neither one of them talked about a living Constitution. The Justice Brennan approach to judging law and rights is simply out of style, as the court and the country have moved to the right. I'm Raymond Brown, and I'll explore the change with a Brennan admirer and a detractor. Expect to see sparks fly, but first, as always, Sandra King is here to set the stage.
Raymond, it's now become a dirty word when applied to judges, but Justice Brennan didn't shrink from the word activist or from the idea of a living constitution, with principles interpreted in the context of a modern world. He may not have been as famous as Justice Marshall or Chief Justice Warren, but his influence on the expansion of individual rights, that may have been greater. It's made him an icon of the left and anathema to the right.
My view of Justice Brennan is that he was misguided.
And Professor Earl Maltz of Rutgers Law Camden is not alone in his skeptical view of Brennan's 34 years on the court.
I also think that he was misguided and that he had, in some ways, almost a contempt for traditional American institutions.
Well, I don't know what he means by contempt for traditional American institutions. He had contempt for segregation and discrimination. Now, that was fairly traditional in this country for many, many years.
Maltz's colleague, Frank Askin at Rutgers Law Newark, who in sharp contrast considers Justice Brennan
the greatest justice of all time. I wouldn't limit it to the 20th century.
In his view, Brennan
had contempt for police abuse of citizens, and he helped to overcome that. He provided more remedies to protect individuals from overreaching by government and police agencies.
But those decisions and scores of others to which Brennan spurred his colleagues on the court for more than 3 decades are explained by Professor Maltz like this.
He believed in what he would describe as an open-ended theory of constitutional interpretation, which to him generally led him to positions that were consistent with what was then the progressive wing of the Democratic Party.
For those of us who believe that the major purpose of the U.S. Constitution is to protect individual liberties and keep government off the backs of the people, Justice Brennan was clearly the most important person who ever sat on the U.S. Supreme Court.
The result, so admired by Professor Askin, was a long series of victories for school desegregation, women's rights, First Amendment rights, welfare rights, abortion rights. the easing of obscenity restrictions and of libel law standards. Those and more that make Brennan a hero of the left and a villain of the right.
For those people who are Justice Brennan fans, I would ask them this question. Would they really want Justice Scalia or Thomas to use the Constitution generally to impose their vision of good public policy on the country?
My response is that Justice Brennan was enforcing the U.S. Constitution. He provided the remedies that the Constitution said the American people have. That was his, he didn't create rights. The rights were there. He created the enforcement mechanisms. That's what he did.
But the strict constructionists, those who subscribe to the original intent of the first framers, say Brennan went far beyond what was actually in the Constitution. And Professor Maltz insists that those on the left applaud what they would condemn if it came from the right.
So if you're not comfortable with having Justice Scalia or Justice Thomas simply impose their general values on the country in the name of the Constitution, then I ask, well, why are you comfortable with Justice Brennan doing that?
Everything can't be spelled out in the Constitution. It was written, more than 200 years ago. Everything wasn't going to be. It's a broad document. It creates certain principles. They have to be interpreted. What does equal protection mean? What does due process mean? What is fundamental fairness? Well, Justice Brennan had a belief that the Constitution was there to protect individuals from government overreaching. It's a view of the Constitution. I don't know if you call that a living Constitution or just common sense. But that was his belief, and I think his belief was absolutely correct.
Absolutely correct or absolutely wrong. It depends on your own judicial philosophy. But as the New York Times put it when he retired in 1990, Justice Brennan's departure from the court brought to an end not only a remarkable judicial career, but also an era in the court's history. Where have we gone since, for better or for worse? Raymond, those are questions that lead to fighting words on the left and on the right.
And Sandy, that's where we're going to pick up when we come back, so stay with us.
My view is that the language of the Constitution ought to be interpreted, that a judge looking at the Constitution ought to decide a case as a judge at the time of the framers' founding would have decided the case, given that knowing all the facts that they knew now.
Brennan said it's the obligation of the federal courts to root out constitutional wrongs, root and branch. And again, that was the tradition of the equity courts. The equity courts had an obligation to provide remedies to implement and protect rights. And that's what Brennan brought to the U.S. Supreme Court from his time on the New Jersey bench.
Wherever his philosophy was formed, it had a profound influence on American justice. Our guests may agree on that much, but probably not much more. Professor Jamal Greene teaches constitutional law at Columbia and once clerked for another liberal justice, John Paul Stevens, while Curt Levey, the president and executive director of the Washington-based Committee for Justice, also frequently writes and speaks on civil rights in the court, but from a decidedly conservative perspective. Gentlemen, welcome to both of you.
Thanks for having me.
Curt, let me start with you,
Sure.
Because you are slightly swimming upstream in the sense that we've been looking closely at Justice Brennan, in part because of a dedication of a park near the courthouse in Essex County. And the overwhelming perspective of many scholars has been twofold. One is that he was among the greatest justices of the 20th century of all time, but also many say that he was at least the greatest liberal justice. You obviously have a different view. Can you boil down to a succinct core your critique of Justice Brennan?
Well, he certainly was one of the most influential justices. There's no doubt about that. whether he was a great justice in the sense of moving the country forward or backward, or at least the law forward or backward, really comes down to whether you believe in judicial activism, whether you believe that a judge's job is to move, a Supreme Court justice's job is to move the law in a certain direction, typically a progressive direction, or whether you believe that a judge should just be a relatively neutral interpreter of the law. Under the latter vision, certainly the one that I hold, Brennan was almost an outlaw justice. Under the earlier vision, I mean, if you want a justice...
When you say the term outlaw, outside of what framework do you mean?
Outside of legitimate powers of the federal judiciary. Basically somebody who took on powers, again, if you like it's sort of like a dictator, frankly. If you like the agenda, you love the dictator. And if you like...
Let me bring Jamal in, because I think we got the succinct, and I know we're going to get more, but there are two issues I think Curt raises. One is that you can define or look at the court in terms of activism or non-activism, and that Brennan took the concept of activism to an extreme. At least that would be Curt's perspective. Do you think that's the framework within which we should be evaluating Brennan and other justices?
Well, I think the use of the term judicial activism too often is used to refer to any justice who sort of disagrees with you. And I think there's a legitimate disagreement among jurists, among lawyers, among academics, as to the appropriate interpretive approach to the Constitution. Justice Brennan believed that the Constitution is not frozen in time, that constitutional rights do change over time, and as society believes different things about themselves. And so I think the best way to understand this debate is really a debate about what kind of people we are, what kind of Constitution we have.
Professor Maltz in Sandy's report said that Justice Brennan showed contempt for American institutions, and Curt used the word outlaw, and I don't think he meant it as a personal attack, but certainly saying that Justice Brennan's views were outside of some mainstream, as opposed to what sounds now like a civil discourse between originalism and a more facile interpretation of the Constitution. Do you think that Brennan can be put outside the framework of American institutional life?
I don't think he can, and certainly for the first half of his career during the Warren Court years, he had majorities in many of the issues that he was, many of the opinions that he joined. He became more of an outlier on the court over time as the country grew more conservative, and so I definitely believe that on the Rehnquist court, on the Berger court, following the Warren court, he was one of the more liberal members of the court. There's no question about that. But to say he's entirely outside the mainstream, I think is not correct.
Curt, let me do this. Keeping in mind that our audience consists of lawyers and non-lawyers, is there a single either case or line of cases or a single kind of decision that you think is the best example of putting Justice Brennan outside the mainstream of American thought, which seems to be where you place him when you say he's an outlaw?
Well, again, when I say outlaw, I mean someone who usurps for himself more power than was intended by
usurps for the federal government or for the court?
In his case, for the court.
Okay.
And to some degree for his own opinions.
Okay.
Although, as the professor points out, he was also very good at convincing his colleagues. And he
Does
did
that
have
count for something when you measure whether he's outside, that he could convince that he could garner majorities?
Sure. I mean, I think that if you look at our whole constitutional history, the Warren/Brennan court for a couple of decades there was, you could say the whole court was outside of the norm. I'm certainly not claiming that judges have been free of bias for 200 plus years, but if you look at the period in which you had the greatest activism.
Let's go back to the Jamal standard,
Sure.
which is if they could garner majorities, including Republican appointees, certainly you could critique them as saying in some broad historical sense they're outside the norm, but in that period of history, how can you say they're outside the norm? Isn't the norm established by the appointment process and the voting process to some extent? Well,
again, you have to remember that it's not. The Supreme Court is not democratic. And that's the problem. The professor talked about the Constitution needing to evolve. Everyone understands that. The Founding Fathers understood that. That's why they gave us an amendment process. It's a democratic process for the Constitution evolving. Most of the great civil rights advances have come through constitutional amendment. That hasn't happened in the last 40 or so years because around the time of the Warren and Brennan court, they realized, you know what? We don't need a majority. We can do it. All you need is 5 justices, and we can do, frankly, whatever we want to do.
Jamal, it sounds like that's a response to your notion that the ability of Brennan and Warren to find majorities for many of the constitutional decisions in the period of the Warren court doesn't reflect mainstream American values, but means the court was outside the mainstream. What's your response to that?
Well, Justice Brennan, his ability to corral majorities in the court does not in and of itself mean that he was within the mainstream. I think it's possible, certainly in a theoretical sense, for the court to be captured by some very extremist, some extremist views, but remember, we're talking about...
Well, do you see him as an extremist?
Not at all. We're talking about protecting civil rights. We're talking about fighting desegregation, fighting in favor of desegregation, fighting segregation. We're talking about fighting for voting rights, fighting for women's rights. These are not extremist positions. These are positions that Justice Brennan, I think, correctly identified as part of our value system.
Let me take the conversation to another level, which is that if we for the moment forget the relationship of the court to the political branches and think of the court as an institution whose job it is in some ways to restrain the political branches. I mean, isn't there an element of the courts having the role of restraining within constitutional limits the political branches?
Sure. When the political branches clearly violate the Constitution, they should be restrained by the courts.
Is there any opinion of the Warren-Brennan era, especially in terms of civil rights or constitutional rights, that you could embrace as within the framework of what a court should properly do?
Well, let me just go back to what the professor said when he was talking about equal protection. I think there's a big difference. You know, we can debate. Brennan took part in some controversial affirmative action decisions. We can debate about exactly what equal protection means, but clearly it was intended to apply to racial distinctions and to obviously convey some sort of equality. So at that point it becomes sort of, you know, two intelligent people can disagree about what it means. But that's a lot different from, say, the right to abortion in Roe v. Wade, which is just not in the Constitution. You cannot point to anything in the original Constitution, the Bill of Rights, or the amendments since then that give a right to abortion or a general right to privacy. And so there's a big difference between making stuff up and having different interpretations of what's actually in the text.
Now, some call making stuff up a penumbra, but before we go back to Jamal, is there anything else you want to put in the Roe v. Wade category so he might respond to it?
I mean, some of the more outrageous, I think, you know, I mean, again, a lot of this stuff sounds great on paper. You know, the idea that every district had to have the same number of people in it, that it was somehow a constitutional violation. Well, you know, I don't think the Founding Fathers thought that, because that's how the Senate works. There's not the same number of people in each state. So the idea that the Founding Fathers somehow, you know, meant to convey to us that every district had to have exactly the same number of people, it's made up. I don't think it's a bad idea. It's just not in the Constitution.
Jamal, do you think that the decisions that Curt's talking about are made up in the sense that he means it made up essentially out of whole cloth, having little to do with the constitutional framework?
I do not think so. I think just taking the second example first, the example of one person, one vote, so legislative districts for the House of Representatives should be equally apportioned. That's a decision based on the Equal Protection Clause of the Constitution, just like the desegregation decision. The Equal Protection Clause doesn't say anything about race. It doesn't say anything about segregation. And yet the Brown versus Board of Education court decided that their interpretation of equal meant that you couldn't separate students by race in schools. Same concept, same principle, a principle of equality, here being applied to voting, that people should, within the House of Representatives, not within the Senate, within the House of Representatives, people should have an equal opportunity to elect representatives.
What about Roe v. Wade? I suspect that when people in the future look back on this era, one of the controversies that probably carried us for 30 years as part of in the public square is the Roe v. Wade controversy.
Sure.
And that seems to be one of the things that Curt says the court just made up, and suggests that the words like penumbra and others that have been used are just constructs. Do you think they're rooted in the Constitution, or do they reflect a court outside of the constitutional duties that it has?
Well, I believe that intelligent person, to use Curt's standard, intelligent people can disagree about Roe versus Wade and the right to an abortion. The question of whether it's made up, well, you have to look back to the precedents that the right to abortion in Roe versus Wade, which I remind you is a 7-2 decision of the court. This is not a 5-4 case. The principles, the precedents that it was based on, which were a right to contraception. In Griswold versus Connecticut, 1965 case, the court says the state of Connecticut has no right to come in and tell married people that they cannot use contraceptives. That's not in the Constitution in the specific sense in which Curt referred to what it is or is not in the Constitution, but the court said, and I think most Americans would agree, that there are certain things the government can't do. It can't tell you how to plan your family. And so Roe versus Wade is based on exactly the same principle. We can disagree.
That's precisely why we don't need a court to do it. Virtually everyone agrees that you should have a right to contraception. And so you don't need activist judges to do it. You can do it in the most extreme case in a constitutional amendment, but you don't even need that. You can do it through legislation. The answer that's often given to defend judicial activism is, well, you know, everyone agrees. Well, if everyone agrees, the democratic process works.
Are you saying that judicial activism only exists on the left? Are there examples of conservative or judges on the right?
I think there's conservative bias, and here's the difference. I think that conservatives generally believe in strict construction, and liberals really do, if you look at their own words, believe that a judge has a moral obligation to move the law along in a progressive direction. That is not to say that conservative judges don't have their biases. They do. But it's the difference between, say, an umpire who believes he should be objective, but sometimes does let his prejudices get in the way, and an umpire who believes it's his job to move the game in the direction of the more, you know, worthwhile, the little team, the disadvantaged team, to give them.
So if we look into the future, Curt, you won't be saying, well, let me ask this question of Jamal, and I'll let you come back to you. Do you think in the future they're going to look back on the Roberts Court, if it turns out that the conservatives have a continual majority going forward, but that there won't be an argument that this was a court that became activist in the conservative sense, and the same critique will have flipped? What do you, let me ask Jamal that first, and then come back to you. Go ahead.
Well, I think certainly that criticism can be levied against the Roberts Court. And just to respond to Curt, I don't think that Justice Brennan or myself would characterize our views as that a judge is obligated to push the court or the country in a particular progressive direction. But just going back to the Roberts Court, the recent decision in Citizens United, which is a case that said corporate expenditures on elections cannot be prohibited under the First Amendment, not consistent with the original understanding of the First Amendment, which was very narrow, not necessarily compelled by the text of the First Amendment, and yet the Roberts, and it's certainly not consistent with the precedents of the Supreme Court. They overturned two.
So why doesn't that fit your definition of judicial activism?
Well, as the professor said, not necessarily compelled. The First Amendment speaks in very broad terms
this is
about.
A very nuanced response, Curt. Go ahead.
Speaks in very broad terms about that the government shall not restrict speech. It doesn't say only the speech of non-corporate individuals, and there's, you know, a long line of cases saying that corporations have First Amendment rights too. Again, I think, you know, plenty of people disagree with the way that decision came out. But when you say, will the Roberts Court be remembered as activist, I don't know yet. Let's see. If they do the equivalent of what the Brennan Court did, if they find that the Due Process Clause, which protects life, constitutionally forbids any abortion, or if they find that some of the family-based precedents or public opinion forbids gay marriage, even if a state wants it, then they will be as activist as the Brennan Court. If that happens, I will eat my words.
I'm going to give you each a chance to give me a laundry list. I'm going to ask you first if you could give me a list with very little time left of the Brennan decisions or Brennan-led decisions that you would reverse if you were on the court now.
Oh, right now.
Right.
Well, again, I think Roe v. Wade is one of them, and not because I'm against abortion as a matter.
You got some more? Because I know your mind is fertile. You must have some more.
I think some of the affirmative action decisions I don't agree with. I really do think that a proper interpretation of the Equal Protection Clause would promote a colorblind society, not preferences, although I realize that people disagree on that. Again, I think the one man, one vote, especially as applied to states.
That's pretty.
Okay,
That's pretty controversial. I'm going to give you the other side. Are there things that you live in dread of opening the New York Times and seeing the report before you've been to the answer sheets that they've overturned precedents from the Brennan-Warren area? What are you concerned about?
Well, actually, I'm not that concerned, in part because I think that a lot of the Brennan-Warren era precedents are so ingrained in American culture and American society that I don't think they're going very far. The one thing that I would mention is the exclusionary rule, which is a little bit of inside baseball, but this is the rule that says that evidence that's obtained illegally is excluded from presentation in court.
How about one man, one vote and Roe v. Wade, which are Curt's
one man, one vote isn't going anywhere. It's too ingrained in our culture, and I actually think that Roe v. Wade is not going anywhere either. I think that part of the point here is that judges are interpreting very broad principles in the Constitution. They're going to disagree. Reasonable people are going to disagree. But the test of whether they're right or not is whether the American people sort of sort of agree with them, sort of agree that this is part of our culture.
I could have this conversation, gentlemen, for hours, and maybe one day we will. But for the moment, my thanks to Curt Levey and Professor Jamal Greene. That's it for this edition of Due Process. But please join us here next week and look for us online at njn.net/due process. For Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
Constitution with certain broad principles. The question is they have to be interpreted and enforced, and that's the role of the courts. And I think Justice Brennan brought a lot of wisdom to that job. You know, it's interesting. Justice Brennan, as he came out of the New Jersey court system, many of our great justices in history, such as Cardozo, Holmes, they were also state court judges before they went to the Supreme Court. So they were steeped in the history of Anglo-American common law and equity tradition. And that's what Brennan was. And that's why they were great justices. They brought real common sense notions to constitutional enforcement.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law. And by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by the PSCG Foundation and the Thomas and Agnes Carvel Foundation.